Welcome to the deep dive. We have a highly targeted mission today.
We really do.
Yeah, we are speaking directly to you, the planner who is currently buried under a mountain of textbooks, studying for a crucial professional exam.
Oh, the pressure is undoubtedly on.
It is, and the sheer volume of syllabus material you have to master can feel, well, completely overwhelming. But take a breath, because today we're going to serve as your shortcut to deeply understanding a really critical piece of that syllabus.
A very critical piece.
Okay, let's unpack this. Our goal over the next chunk of time is to thoroughly master two landmark Canadian Supreme Court cases. Cases that have fundamentally rewired everything about land use planning, environmental assessments, and Crown Indigenous relations in Canada.
We are tackling the Tsilhqot'in Nation v. British Columbia decision from 2014 and the Taku River Tlingit First Nation v. British Columbia decision from 2004.
Right. And as a future planner, these aren't just historical footnotes. They are the operating system for your entire career.
They truly are the operating system. What's fascinating here is that these rulings actively move the needle from abstract, high-level constitutional theory to the practical, boots-on-the-ground realities of land management.
Yeah, the everyday stuff.
Exactly. They establish the modern legal bedrock for what Aboriginal title actually is. They define the very real limits of provincial regulatory power. And they spell out exactly what the Crown's duty to consult looks like when you are sitting at a planner's desk trying to process a permit.
By the end of this deep dive, you are going to understand the mechanics of these legal frameworks so well that applying them on your exam is going to feel like second nature.
Absolutely.
So let's jump right into the first case. Tsilhqot'in Nation. To understand the law, we first have to understand the geography and the conflict.
Right, the background.
Yeah. We are looking at a semi-nomadic group of 6 bands living in a remote, incredibly beautiful valley, bounded by rivers and mountains in central British Columbia. And the core conflict kicked off back in 1983.
When the province issued those commercial logging licenses.
Exactly. On land that the Tsilhqot'in people considered their traditional ancestral territory. So naturally, the Tsilhqot'in objected to the clear-cutting. That led to a physical blockade of a bridge and eventually a massive, unprecedented lawsuit.
Unprecedented is the right word. The trial alone took 339 days.
Which is wild.
Stretched over 5 years. It was an absolute marathon. And that marathon trial was necessary because of the sheer complexity of proving historical occupation.
The trial judge actually spent long periods out in the remote claim area with elders and witnesses, right?
He did, trying to deeply understand how the land is traditionally used. And that extensive time out in the bush led to the central legal battle of this entire case.
Which was how to define occupied land.
Precisely. How the Canadian legal system should define occupied land for the purpose of granting Aboriginal title. The province and the BC Court of Appeal pushed really hard for what we can call a postage stamp approach.
A postage stamp approach.
Yeah, they argued for an intensive, site-specific test. Their logic was that for a semi-nomadic group, title should only be granted to specific permanent settlement sites or areas of highly intensive use.
Which would result in these tiny, isolated small islands of recognized title, completely surrounded by vast, unbroken tracts of crown land.
But the Supreme Court saw right through that small islands theory. They realized you cannot force indigenous land use practices into the rigid square boxes of European common law.
So they adopted a territorial approach instead.
Yes. The court ruled that for semi-nomadic peoples, regular and exclusive use of broader territories like moving through valleys for hunting, fishing, trapping, and foraging is absolutely sufficient to establish occupation.
It doesn't require permanent stone buildings to be considered occupied territory.
Exactly. And that territorial approach completely shifted the landscape of Canadian law.
Okay, so for your exam, you need to know exactly how a First Nation proves that territorial occupation.
The Supreme Court laid out a 3-part test for establishing Aboriginal title. The first hurdle is proving sufficiency of occupation.
Meaning the Aboriginal group must show they have historically acted in a way that communicates to third parties that they held the land for their own purposes.
Crucially, the Supreme Court mandated that this must be evaluated from both the common law perspective and the Aboriginal perspective.
That dual perspective makes a lot of sense, especially when you consider the carrying capacity of the land.
Right, the ecological limits.
Yeah. If a specific valley in central BC only supports a small population of hunter-gatherers because of harsh winters, their specific seasonal patterns of regular use are sufficient to prove occupation.
They don't need to show they had thousands of people occupying every square inch year-round.
Exactly. But demonstrating that historical use leads to the second hurdle the court required. continuity.
It wasn't enough for the Tsilhqot'in to just show they were using the land when the logging trucks arrived in the 1980s.
No, the court needed to see a historical bridge. They had to prove a continuous link from the time Europeans asserted sovereignty over that specific area, tracing all the way up to the present day.
And establishing that unbroken chain over centuries is a monumental evidentiary task.
It really is.
Once a group proves sufficiency and continuity, they hit the final requirement, exclusivity.
Which focuses on the intention and capacity to control the land.
The court asks, did this group historically exclude others from their territory? Or, if other indigenous groups were present on the land, were they only allowed access with the express permission of the claimant group?
Right, if they were demanding permission from outsiders who wished to pass through or hunt in that valley, that demonstrates a clear intention and capacity to control the territory.
And the Tsilhqot'in successfully proved all three elements: sufficiency, continuity, and exclusivity.
Because of that, the Supreme Court granted the first ever declaration of Aboriginal title to a large tract of land in Canadian history. It was a watershed moment.
It changed everything.
So, what does this all mean for the government, and more specifically for a planner? When a court declares that a First Nation holds Aboriginal title, what actual rights are being conferred?
It confers incredibly robust, ownership-like rights. Aboriginal title gives the First Nation the right to use and control the land, the right to enjoy its occupancy, and heavily emphasized by the court, the right to reap its economic benefits.
So it's a proactive right.
Very much so.
Yeah.
It's a proactive right to manage the land and decide how it will be used today and into the future. It's not a museum piece restricted to traditional or historical uses.
So if the title holders decide they want to use their land for modern economic development, say a commercial enterprise or a new infrastructure project, they have the legal authority to do so.
They do.
But there is an inherent limit to this title, which I find to be one of the most compelling legal concepts in the syllabus. Think of Aboriginal title like a precious family heirloom. Let's say your grandparents hand down a historically significant, incredibly valuable antique watch.
Okay, I like this analogy.
You have the right to wear it, enjoy it, and maybe even display it in a museum for an economic benefit. But you do not have the right to smash it with a hammer or melt the gold down for scrap metal.
Because that watch doesn't just belong to you.
Exactly. It belongs to your children and their children.
That multi-generational fiduciary concept is the exact legal mechanism the court applied. Aboriginal title is a collective group interest that inherently belongs to present and future generations.
Therefore, the land cannot be alienated.
Meaning it can't be sold to anyone except the federal crown.
Right. And it cannot be developed in a way that would substantially deprive future generations of the benefit of the land.
So if a specific tract of title land is essential for a core cultural practice, the title holders couldn't authorize strip mining it in a way that permanently destroys that capability for their great-grandchildren.
Which brings us to a massive practical question for the exam. If title is established and protected for future generations, can the provincial or federal government ever override it?
The short answer is yes. But the bar is staggeringly high. The Crown can infringe on Aboriginal title, but they are forced to use the justification framework under Section 35 of the Constitution Act, 1982.
The government has to clear three distinct hurdles. First, they must prove they discharge their procedural duty to consult and, if appropriate, accommodate the First Nation. They cannot simply act unilaterally.
The second hurdle is that the government's actions must be backed by a compelling and substantial objective. They need a genuinely critical reason to interfere with title land.
This could be something like developing a central regional infrastructure or managing a severe environmental crisis.
Right. In the Tsilhqot'in case, the province actually tried to argue that their commercial logging authorizations were justified to prevent a massive mountain pine beetle infestation from spreading.
Oh, right. But the court didn't buy it.
The court listened to that argument, but ultimately found the province's evidence completely lacking, essentially tossing out that justification.
Assuming the government does have a valid, compelling objective, they still have to clear the third hurdle, proportionality. This is deeply tied to the Crown's fiduciary duty to the Indigenous group.
The government action has to be rationally connected to their goal. It must impair the Aboriginal right as little as humanly possible. That's the minimal impairment standard.
And finally, the expected societal benefits of the government action must actually outweigh the adverse effects on the Aboriginal interest.
So if a planner is working for the province, and they can't check every single one of those boxes with solid evidence, the government cannot infringe on the title.
Now, does the BC Forest Act even apply to Aboriginal title lands? That's a huge conflict of laws issue.
If we connect this to the bigger picture of Canadian constitutional law, this Section 35 framework fundamentally altered the division of powers. Before this ruling, planners and lawyers wrestled with a doctrine called interjurisdictional immunity.
Oh, that old doctrine.
Under the Constitution Act, 1867, the federal government has exclusive power over Indians and lands reserved for the Indians. Meanwhile, the province holds the power over property and civil rights, which includes things like forestry and resource management.
So for decades, the prevailing argument was that applying provincial laws to Aboriginal rights would unconstitutionally infringe on the core of federal jurisdiction.
Exactly. Under that old theory, provincial laws were essentially immune or completely inapplicable on Indigenous lands.
Think of it like a football game where you have two referees on the same field trying to enforce completely different rule books.
That's a great way to picture it. But the Supreme Court completely threw out that idea of interjurisdictional immunity in the context of Aboriginal title. They realized that maintaining that doctrine would create an absolute nightmare for land use planning.
It would have resulted in a massive, unworkable regulatory patchwork.
Imagine a planner trying to manage a forest ecosystem where provincial logging and environmental laws apply on one side of an invisible boundary line, but instantly cease to apply on the other side.
You'd have overlapping legal tests, dueling regulatory bodies, and massive jurisdictional vacuums.
It would make effective landscape-level resource management practically impossible.
So to avoid that chaos, the court ruled that general provincial laws like the British Columbia Forest Act do apply to Aboriginal title lands.
But they apply with strict conditions. They cannot cause unreasonable hardship, they cannot deny the title holders their preferred means of exercising their rights, and most importantly, they cannot unjustifiably infringe on those Section 35 rights we just unpacked.
The Section 35 justification framework does all the heavy lifting to protect the Aboriginal rights, so that blunt, chaotic instrument of interjurisdictional immunity simply isn't needed anymore.
However, the application of provincial law is not a blank check. In the Tsilhqot'in case specifically, while the Forest Act technically applied to the territory, the province utterly failed the Section 35 justification test.
Because they couldn't prove minimal impairment or a compelling objective, right?
Exactly. Their specific forestry authorizations were found to unjustifiably infringe on the Tsilhqot'in's title, rendering those logging permits invalid.
So Tsilhqot'in gives us the ultimate rulebook for what happens when Aboriginal title is an established, undeniable, court-declared fact. But let's bring this back to your future desk as a planner. In the real world, you are usually operating in the gray area.
The vast majority of the time, yes.
The lands you will deal with do not have court-declared Aboriginal title yet. You'll be dealing with land where title is strongly asserted by a First Nation, but hasn't spent 20 years working its way through the courts.
How does the government manage that uncertainty?
That exact question requires us to shift our timeline back a decade to 2004 to our second landmark case, Taku River Tlingit First Nation, or TRTFN.
Navigating that intermediate period is arguably the most common challenge a planner will face. The Taku River case provides the definitive blueprint for how the Crown must act before title is proven.
The facts here are straightforward, but highly consequential.
In 1994, a company called Red Fern Resources proposed reopening the old Tsilhqot'in mine in northwestern BC.
And to make the mine economically viable, they needed to build a 160-kilometer access road cutting straight through a pristine, remote area of the Taku River Tlingit First Nations traditional territory.
Naturally, the TRTFN strongly opposed the road, citing their unproven but deeply historical claim to the land.
And this scenario triggers a foundational constitutional principle known as the honor of the Crown. The Supreme Court made it abundantly clear that the government cannot simply sit on its hands, ignore the First Nation, and wait for a decades-long court battle to formally declare title before taking their concerns seriously.
The duty to consult is triggered the very moment the Crown has real or constructive knowledge of the potential existence of an Aboriginal right or title, and contemplates any conduct that might adversely affect it.
The phrasing real or constructive knowledge is vital for a planner to understand.
It means the government can't play dumb. If there are historical records, ongoing treaty negotiations, or previous land use studies indicating a First Nation claims the area, the Crown has constructive knowledge.
And if the government is contemplating issuing a permit for a 160-kilometer mining road through that area, the duty to consult is immediately activated, period.
Here's where it gets really interesting, though. That creates a massive logistical puzzle for the Crown.
If the government has to consult on every single unproven claim, how much consultation is actually required? Does a routine permit to repair a culvert require the premier to sit down for a month of intense negotiations?
To solve that logistical puzzle, the court introduced the concept of the sliding scale. Think of it somewhat like a triage system in a hospital emergency room.
Right. A scraped knee requires different resources than a cardiac event.
Exactly. In planning, the scope and depth of the duty to consult is proportionate to two main variables. The first variable is the strength of the prima facie claim.
Meaning, on its face, looking at the preliminary evidence, how strong is the First Nations' historical claim to the land?
And the second variable is the seriousness of the potentially adverse effect upon the right or title being claimed.
Let's apply that hospital triage analogy directly to the Taku River case. First, we look at the strength of the claim. In this case, the TRTFN had an exceptionally strong prima facie claim.
Their land claim wasn't just a vague assertion. It had already undergone extensive validation and was formally accepted into the BC treaty negotiation process years prior.
So the first variable on the sliding scale is cranked all the way to high.
Then we look at the second variable, the seriousness of the impact. A 160-kilometer road carved through a remote, pristine wilderness is not a minor footprint.
Expert testimony during the process noted that a road like that acts as a permanent magnet for future development.
Potentially altering the landscape irreversibly and fundamentally disrupting the TRTFN's traditional domestic economy.
Because both the strength of the claim and the severity of the impact were exceptionally high, the TRTFN was entitled to deep consultation. The Crown couldn't just mail them an information packet and give them 30 days to write a response letter.
So as a planner, if you see high claims strength and high impact severity, you know you are designing a deep consultation process.
How did the province actually meet this heavy burden in the Redfern mine scenario? Because ultimately, the Supreme Court ruled that the province did successfully fulfill its constitutional duty.
They achieved this deep consultation by funneling the project through the rigorous process of the Provincial Environmental Assessment Act.
Integrating consultation into the environmental assessment process is a standard approach you will see repeatedly in your career.
This was not a quick bureaucratic rubber stamp. The TRTFN was invited to be an active part of the official project committee.
They participated deeply in the environmental review process, sitting in meetings, reviewing technical data, and voicing concerns for over 3.5 years.
But the outcome wasn't a perfect consensus. The TRTFN wasn't happy at the end of those 3.5 years.
They actually opted out of the project committee near the very end and submitted a formal minority report disagreeing with the project's approval.
They felt the process was rushed at the conclusion and that their deep concerns about baseline environmental information weren't fully addressed by Redfern.
The minority report is a crucial detail because it highlights the vital legal distinction between consultation, accommodation, and a veto.
Even though the TRTFN submitted that minority report, the province did not just file it away and ignore their concerns.
To meet the standard of meaningful accommodation, the province took the TRTFN's input and attached significant, legally binding mitigation strategies to the project approval certificate.
For instance, they made it a strict condition that Redfern had to develop much more detailed baseline environmental information at the subsequent permitting stage.
They also strongly recommended the establishment of a joint management authority to oversee the road. The province tangibly adapted its requirements based directly on the First Nations' concerns.
And this leads to perhaps the most critical exam takeaway for our listening planner. Meaningful consultation and accommodation require good faith and real compromise, but they do not guarantee an agreement.
The Supreme Court was remarkably clear on this point. Consultation is an attempt at reconciliation.
It is a mandated attempt to reasonably balance Aboriginal concerns with broader, competing societal concerns, like regional economic development. But it does not give the First Nation an absolute veto over the project.
Where consultation is deep, meaningful, and results in tangible accommodation, there is no ultimate legal duty for the Crown to reach a perfect consensus.
The court looked at the 3.5 years of studies, the integrated committee meetings, and the specific project modifications, and concluded that the province had thoroughly fulfilled its honorable duty to the TRTFN, even though the final project was approved over their formal objections.
Okay, let's do a quick high-level exam prep wrap-up to solidify these massive concepts for you.
Sounds good.
From the Tsilhqot'in case, you must remember the 3-part test for establishing Aboriginal title. Sufficiency of occupation based on carrying capacity, historical continuity, and exclusivity.
You need to know that title gives the proactive right to economic management, subject to the inherent multi-generational fiduciary limit.
And you must understand that the Section 35 justification framework, not interjurisdictional immunity, is how the courts handle conflicts with provincial regulations.
And stepping back to the Taku River case, your major takeaway is the mechanics of the pre-proof duty to consult and accommodate.
Remember the trigger. The honor of the Crown is activated by mere knowledge of a claim combined with contemplated adverse action.
Remember the sliding scale. The depth of consultation is proportionate to the strength of the prima facie claim and the severity of the impact.
And finally, remember that deep consultation via processes like environmental assessments requires tangible accommodation, but it does not equate to an absolute indigenous veto.
If you can articulate those core principles and how they connect to a planner's daily reality, you are going to absolutely nail this section of your syllabus.
Oh, doubt.
This raises an important question, though. Something to mull over as you close your textbooks and look towards your future career.
Okay, what is it?
We learned in Tsilhqot'in that Aboriginal title includes the proactive right to the economic benefits of land. But we also learned it inherently forbids developments that would substantially deprive future generations of the land's benefit. So, how will your generation of land use planners navigate modern green energy megaprojects on indigenous lands?
Wow, that is a great question.
Are massive wind farms or thousands of acres of solar arrays a protected modern economic benefit for the title holders? Or do they constitute an irreversible permanent change to the landscape that violates that multi-generational fiduciary duty?
That is a massive, complex balancing act, and it's exactly the kind of nuanced puzzle you will be solving in your career. Thank you for joining us on this deep dive into Canadian land use law. Best of luck on your exam. You have the tools, you know the frameworks, and you are going to do great.